opinion will say content. Contrary, not content. The contents have it. In clause 18, Amendment 77, Baroness Fox.
My Lords, I'm rather disappointed that while this is a large group on freedom of expression, it's dominated by amendments by myself and the noble Lord Moylan. I welcome Baroness Fraser of Craigmaddy and Lord Stevenson of Balmacary dipping their toe in the free expression water here, and I'm glad that the Minister has added his name to their amendment, although it's a shame he didn't add his name to one of mine. But anyway, earlier today we heard a lot of congratulations to the government for listening. I have to say it depends who you are, because he hasn't listened to all of us. And it's notable that of the hundreds of new government concessions that have taken the form of amendments at this report stage, none of them relate to free speech. So before I go through my amendments, I just wanted to note that when Lord Moylan and I raise concerns about free speech, it can be that we get treated as being slightly eccentric. There's been a generally supportive and generous mood from the regulars in this House. I understand that. But I do worry that free speech is being seen as peripheral. But this country and our country that we legislate for and in has a long history of boasting it is the home of liberty, of adopting a liberal approach, that being free is the default position, that free speech and the plurality and diversity of views it engenders is the cornerstone of democracy in a free society, and that any deviation from that approach must require extraordinary and special justification. So it seems to me that with a comprehensive piece of law, such as the one we're dealing with, that challenges many of those norms, it really does deserve thorough scrutiny through the prism of free speech. And to be honest, when I approached this bill, which I've been following long before I arrived in this House, I assumed that there would be packed benches, a bit like the illegal migration bill, and that everybody and all these law lords would be in, quoting the European Court of Human Rights on Article 8 and Article 10, that there'd be complaints about executive power grabs and so on. But it's been a bit sparse. Now that's okay, I can live with that if it's a bit dispiriting. But I am concerned when the government then cite that the mood of the committee has been reflected in their amendments, because it's not been a very large committee, is my point. But many of the amendments that myself and the noble Lord Moylan, but others, representing the, talking about free expression, are representing the concerns of a wide range of policy analysis, civil rights groups, academics, lawyers, free speech campaigners, and industry representatives, and they've been put forward in good faith, and I continue to do that, to suggest ways of mitigating some of the grave threats to free speech in this bill, with constructive ideas about how to tackle flaws and raising some of the problems of unintended consequences. But I have at times felt that those concerns were just batted away with a certain indifference. Despite the Minister being very affable and charming, nonetheless it can be a bit disappointing. So anyway, I'm here to bat again. And I really hope that the government now will listen very closely and consider how to avoid the UK ending up having the most restrictive internet speech laws of any Western democracy at the end of this. I have a lot of different amendments in my name in this group, but just to note that I do support wholeheartedly Lord Moylan's amendments requiring Ofcom assess the impact of their codes on free speech, but I won't speak to them. So let me just talk about my amendments. Starting with Amendments 77, 78, 79, 80 and 81, these require platforms to have particular regard for freedom of expression, not just when implementing safety measures and policies, but also when writing their terms of service. This is to ensure that freedom of expression is not reduced to an abstract, have regard to secondary notion, but should be visible in drafting terms of services. And that would mean that users know their rights in clear and concrete terms. So, for example, if a platform should be expected to justify how a particular terms of service on something like religious hatred will be balanced with consideration of freedom of expression and conscience in order to allow discussions over different beliefs to take place. Users need to be able to point to specific provisions in the terms of service setting out their free speech protections. And this is all about parity between free speech and safety. Although the government, and I welcome this, has attempted some balance via Clause 18 to mitigate the damage to individual rights to free expression from the bill, it's a rather weak, poor cousin, in my opinion. And so we have to recognise that if companies are compelled to prevent and minimise so-called harmful content via operational safety duties, these amendments are saying that they should be parity on free expression, and they should be compelled to do the same on free expression with a clear and positive duty, rather than Clause 64, which is framed rather negatively. Amendment 188 takes on the issue of terms of service from a different direction, attempting to ensure that duties with regard to safety must not be allowed to restrict lawful expression or that protected by Article 10 of the European Convention on Human Rights, that states that interference in free speech rights is not lawful unless a last resort. And just to note, in case anyone's reading the amendment carefully, and for Hansard, that the amendment actually reads Amendment 8, a rather Freudian slip on my part and not corrected by the Bill Office. It's probably because privacy rights are also threatened by the bill, but I mean Article 10, of course. This Amendment 188 addresses a genuine dilemma in terms of Ofcom enforcing safety duties via terms and conditions that will transform private agreements between companies and users into statutory duties under Clause 65. This could mean that big tech companies would be exercising public law functions by state-backed enforcement of the suppression of lawful speech. And one worry is that platforms' terms of service are just not neutral. They can change due to external political or commercial pressures. We've all been following with great interest what's happening at Twitter and so on. And they are driven by values that can be at odds with UK laws. So I hope the Minister will answer the query that this amendment poses. How is the UK able to uphold its Article 10 obligations if state regulators are legally instructed to enforce terms of service attitudes to free speech, even when they censor far more than UK domestic law requires? Amendment 162 has a different focus and removes offences under Section 5 of the Public Order Act from the priority offences to be regulated as priority illegal content as set out in Schedule 7. This amendment is prompted by a concern that the legislation enlists social media companies to act as a private online police force and to adjudicate on the legality of online content. And this is especially fraught in terms of the legal limits on speech, where illegality is often contested and contentious offline as well as on. The inclusion of Section 5 would place a duty on service providers to take measures to prevent individuals from ever encountering content that includes, quote, threatening or abusive words or behaviour or disorderly conduct. And that is likely to cause harassment, alarm or distress. It would also require service providers to minimise the length of time such content is present on the service. Now, I'm not sure if my noble lords have been following a dispute that broke out over the weekend, in which there's a film on social media doing the rounds of a trans speaker, Sarah Jane Barker, at a trans pride event, screaming pretty hysterically, "If you see a TERF, punch them in the effing face," and I'm being polite. You'd think that that misogynistic threat would be the crime that people might be concerned about, yet some apologists for trans pride claim that those women, TERFs such as myself, who are outraged and have been retweeting the speech as saying that, are the ones who are stirring up hate. Now that's a bit of a mess, but asking service providers or indeed algorithms to entangle such disputes can surely only lead to the over-removal of online expression or even more of a muddle. As the rule of law charity Justice points out, this could also catch content that depicts conflict or atrocities, such as those taking place in the Russia-Ukraine war. And Justice asks if the inclusion of Section 5 of POA could lead to the removal of posts by individuals sharing stories of their own abuse or mistreatment on internet support forums. Additionally, under Schedule 7 of the bill, versions of Section 5 could also be regulated as priority legal conduct, meaning that providers would have to remove or restrict content that, for instance, encourages what's called disorderly behaviour, and that is disorderly behaviour that's likely to cause alarm. And various organisations are concerned that this could mean that content that portrays protest activity that might be considered disorderly by some, unless you actually condemned it, could be removed, or that even content that encourages people to attend protests would be in scope. Now, I'm not a fan of Section 5 of the Public Order Act that criminalises stirring up hatred at the best of times, but at least those offences have been and are subject to the full rigour of the criminal justice system and case law. And of course, the courts and the CPS and the police are also bound by, for example, Article 10 to protect free speech. But that's very different to compelling social media companies, their staff or automated algorithms to make such complex assessments of Section 5 threshold illegality. Through no fault of their own, these companies are just not qualified to make such determinations. And it's obvious that that could mean that legitimate speech will end up being restricted. And it also dangerously makes a significant departure from the UK's rule of law in deciding what's legal or illegal speech. And I think it has the potential to limit UK users' ability to engage in important aspects of public life and prevent victims of abuse from sharing their stories, as I've described. Finally, the last amendment, I'll keep this short for time's sake. I won't go into the detail. It's Amendment 275, but I do hope the Minister will take a look at this and see that there's a loophole and discuss it with the department. In skeleton form, the Free Speech Union has discovered that the British Board of Film Classification runs a mobile classification network, an agreement with mobile network providers that means that the BBFC advises mobile providers on what content should be filtered because it's considered suitable for adults only. This arrangement is private, not governed by statute, and as such means that even the weak free speech safeguards in this bill can be sidestepped. And this affects not only under 18s, but anyone with factory setting on their phone. And it's led to a particular bizarre outcome when last year the readers of the online magazine The Conservative Woman reported that the website was inaccessible. This small online magazine apparently was blacklisted by the BBFC because of comments below the line on their articles. The potential for such arbitrary censorship here is a real concern, and the magazine can't even appeal to the BBFC. So I do ask the Minister to take this amendment back to the DCMS, who helped set up this mobile classification network, and find out what's going on. I think this peculiar odd tale illustrates my concerns about what happens when free speech is not centre and front, even when you're concerned about safety and harm. I worry that when free speech is casually disregarded, censorship and bans can become the default and a thoughtless option, and that's why I really do urge the Minister, before the third reading, to at least make sure that some of the issues and amendments in this group are responded to positively.